Look at these 3 words written larger than the rest, with a special pride never written before or since. Tall words proudly saying, "We the people."
Welcome to the Lex Rex Institute podcast. I'm your host, David Truschel, the lead writer for the Lex Rex Institute.
Yeah, we've got a fun episode today planned, don't we, David? Anyway, I'm your co-host, Alexander Haberbush. I'm president of the Lex Rex Institute. I'm also a constitutional attorney, though I'm not going to be speaking in that capacity today or ever on this podcast.
I find it very interesting that you just sort of buried a question for me in the millisecond before you moved on, but that's fine. Anyway, before we begin...
You're not going to answer?
No, I don't think so. You didn't really give me the chance, so it's on your own head. Anyway,
David doesn't think it's an interesting episode. He thinks it's a boring one.
Yeah, that's right. Before we begin, please note that all opinions expressed in this podcast, including that one that it's going to be a boring episode, are the opinions of the individuals expressing them, not necessarily the opinions of the Lex Rex Institute.
The Lex Rex Institute is a nonprofit constitutional advocacy organization. If you want to learn more about our organization's activities or make a donation, I highly recommend that one. Please visit our website, lexrex.org. That's LEXREX.org. And as a reminder, this podcast is a legal issues podcast, not a political issues podcast. We try to keep our commentary strictly to legal issues. And, as even Alexis de Tocqueville noted, in the U.S., legal issues invariably tend to become political ones. And today, we now have more issues that are considered political than ever before. So we think it's especially important to distinguish between the two. That's one of our major goals and projects on this podcast. Our name, Lex Rex, is Latin for the law is king, because we believe that there's really only 2 options in America. Either the law is king or man is king. And you really don't want the latter one to be true. So that's our name, Lex Rex, law is king. We want to keep everybody accountable to the law. So, David, interesting episode, right?
I guess that depends on what you think about French Revolutionary history, but that is one of the things we're going to be talking about today.
Well, I was just thinking, because it's a podcast about American law, it's a little bit weird, but we're spending half the episode talking about France and French law.
Well, to be fair, it's probably going to be more than half, but that's, the point is...
Oh, that makes it less weird. You're right.
Yeah, no, that's exactly right. For those of you who were listening a few weeks ago when we did our 4th of July episode, one of the things we're going to be doing this summer is comparing the French Revolution and, what has come to be called the American Revolution. As you pointed out earlier, wasn't common to call it that until after the French Revolution had begun.
Yeah, we're not real fond of that term. We really prefer American War of Independence, American Independence Movement, because that's what it was. We became independent. We did not revolt. We were the law abiders. They were the ones revolting. And it was quite revolting.
I was going to say, is that a joke about British teeth? But anyway.
Yes.
But, and, one of the things that I think is misguided about a lot of American education is that we tend to get taught that, the American Revolution and the French Revolution go hand in hand. They're basically the same thing. Maybe the French went a little too far. We'll get, into some of that today, probably.
And part of that's understandably due to the fact that some of our founding fathers, not all, not even most really, but some of our founding fathers spoke favorably of the early stages of the French Revolution when it still could have gone that direction. Those comments have sort of not aged particularly well.
Yeah. But one of the things that we're going to be looking at is why it's probably not actually a very close comparison at all. And we'll get into that a little bit later. When we started off with the America side of things, we were looking at the Declaration of Independence. Later in this episode, we'll be looking at the French Declaration of the Rights of Man and the Citizen. But
we'll take a look later on this episode. If you want to learn more about the philosophical foundations of our Constitution, the good Constitution, good philosophical foundations, check out our website, lexrex.org. We've got a store there where if you make a contribution to us of, I think, starting as low as $20, you can get a free book that is really goes into American law, the foundations of American law. I recommend John Locke, the Constitution, Declaration of Independence themselves, or we've also got a more modern one, so less philosophical foundations, but Gorsuch's A Republic, if you can keep it. So without further ado, we're also discussing one case today. David, what's that case?
We'll be talking first about Carson v. Makin, and I'm assuming it's Makin and not Makin or something like that. It'd be kind of dumb, in my opinion, if it's pronounced that way because it's spelled M-A-K-I-N, so we're going to go with Makin. But this is another one.
It's making me crazy.
Oh, man, that's bad. I really want to cut that. I think I'm going to cut that, but
Don't cut that.
we'll see. Anyway, this is another instance where we're playing a bit of catch up, as we mentioned in the last couple of episodes. Some huge news at the court pushed some things we were going to talk about earlier.
Probably the most significant Supreme Court term in any of our lifetimes. Whether you like it, whether you hate it, a lot happened, and we're going to be playing catch up on that for a little while.
Yeah. So this is another one that just about decided literally a month before we're talking about it. The decision on this one came down on, actually quite literally a month, since we're doing this a day early, actually. It was decided on June 21st. But
yeah, we're actually doing this a day early because I'm flying out to D.C. again, this time for a gala at the Supreme Court where I'm actually going to meet some of the justices. That should be exciting. Hopefully we'll have pictures for you guys from that. So watch ahead for what's coming in LexRex News, because that's sort of a big deal.
Yeah. Well, without further ado, I guess we should get into it. Carson v. Makin was another First Amendment free exercise issue. We've talked about one, maybe two others earlier on this podcast.
We had the Kennedy case. That was first. Yeah, that was debatably. They turned out to be free exercise, also free speech. But
yeah, but that one was huge for sort of the specific jurisprudence around First Amendment issues. This one wasn't quite as significant in that direction, but I think still a noteworthy decision. So basically, what happened in this case is that the state of Maine has a program that offers tuition relief to students in remote parts of the state, and there are lots of remote parts of the state. I don't know how many have been to Maine, but not a lot of civilization once you get into some of those further reaches. But students in remote areas where where the state does not actually operate public schools, and there are, more than a few of those areas.
Sounds like heaven.
Well, anyway, so the idea
somewhere that doesn't have public schools. Hey, if you've been following LexRex at all, you know about all the litigation we have against public schools right now. Some of these public schools set themselves up as almost petty fiefdoms, where school administrators view themselves as fief lords, can do whatever the heck they want. We're going to hold them accountable, though, so watch our news for that. I'm going to keep saying that about everything tonight, I think.
Yeah, pretty much. Also, for those of you who aren't familiar with what the word fiefdom means, which again, that's one that you probably don't need to know, but
it's where man is king, not the law.
A little lordship, a little place where, some nobleman rules.
Where man is king. It's very opposite of what we're advocating for. So
anyway, and we support, parents who, as we had a piece up recently, or rather you had a piece up recently about one of our current cases that involves a public school. And to make it plain on the record, we support parents who want to use public schools. We support parents who don't want to use public schools. But in either case, we will stand up for the rights of parents and their children in their schools.
We actually offer a lot of homeschool curriculum for homeschoolers because, homeschooling is great too. I think homeschooling is a great idea, for people who are able to do that, but that's not everyone. And the fact that, homeschooling might be a great option doesn't mean that we should just resign our public schools to wherever the heck they're going to go. So we're going to fight back on that. That's the Boyle case. It's actually been kind of a big media issue over the past couple of weeks. I think Fox News has mentioned that case of ours pretty much every night. I appeared on Fox last week to talk about that. This ridiculous case. I mean, that's why it's gotten as big as it has in the media. And it should be a very significant case. So that's one to keep your eyes on. Yeah. But anyway, here's another. Sorry, David, go ahead.
I was just going to say, if you want to hear more details about that, because we don't really have the time to get deep into the weeds on that case here. But if you want to know more, there's information on our website. Again, that's lexrex.org. You can also look us up on YouTube and find, I think, at least the clip of you on Fox and maybe some other things I can't remember off the top of my head. But anyway,
think we try to put a lot of the stuff up there if we can get recordings of it. So take a look there. I'm sure there's stuff on the Boyle case.
Yeah. Anyway, but back to
I
Maine.
was saying, you were talking about how there's some parts of Maine that don't have government schools, and I said, sounds like heaven. That led into a bit of a tangent. So where were you, David?
Anyway, so the idea is they offer this program, the state of Maine does, to parents of children who live in those districts, can't use a public school. So, to help offset the cost of tuition at private schools, or in some cases, I think just to cover transportation to a public school, they have public assistance for that. Now,
people are paying taxes to support the schools.
Yeah.
Because it doesn't matter. Even if you live out in the boonies where there are no public schools, you still pay taxes for them. So they wanted to make sure people were getting some benefit.
Right. Now, the case in question arose when a couple of families who wanted to send their children to Christian schools were denied access to those funds. And basically the state said, we specifically exclude, I think they use the word sectarian schools from this program.
Yeah, and that's based on some real old Establishment Clause jurisprudence. Remember, Establishment Clause says that Congress shall not establish a religion. Remember, established churches are basically state churches. So state endorsements of religion, states doing things to benefit religious causes, can be read as state churches, state endorsements of religion. That's the Lemon Test. We talked about the Lemon Test before. That's actually gone now. And this case is, well, it's free exercise and an Establishment Clause case. Most of them tend to be, because those have, at least during the 20th century, been viewed as sort of two opposites need to be balanced against each other.
Right.
But yeah, David, what's the issue in this particular case?
So, basically the challenge came down to these parents saying, we have a right to make use of this public program, which exists to help educate children. We want to be able to use that benefit where we choose to. And the state disagreed. And it ended up before the Supreme Court. And ultimately they decided 6-3. So this is one of those ones that tends to split, what you could call the right and left wings of the court. The dissenting votes were Justice Sotomayor, Justice Kagan, and Justice Breyer. That's a pretty typical, quote unquote, left wing arrangement.
And I just want to be clear. That's not necessarily because of political differences among the justices.
Right.
People who are originalists, have an originalist view of the Constitution, tend to be a lot more suspect of balancing tests, where you look at one interest, you look at another interest, and you try to balance the two of them. They tend to be a lot more strongly in favor of sort of absolutizing rights, that this right's going to apply in all circumstances. We're not going to balance it against other interests. And you can see why that would produce the result that it did in this case. If you're balancing the interest in the state not endorsing religion against basically the interest in these people being able to educate their children as they see fit and get the benefit of their tax dollars, you can see why somebody might fall on the side of, we're just going to steal your money and give you no benefit. I mean, I still don't think that I would go there, but I can see why somebody might. Whereas if you view the idea of free exercise of religion as absolute, obviously not going to go there. So that's how it's split, but not necessarily for political reasons.
Yeah. And at some point we might want to devote an entire episode to this topic, but for various reasons, originalism has tended to be associated with political conservatism. But as you point out, that's not necessarily an intrinsic link.
No, not at all.
And
not in the slightest, actually.
Well, we can maybe talk about.
I mean, you could say that some originalist judges would not be originalists if they didn't expect that the Constitution was largely going to endorse conservative principles. But the two are not related.
Yeah, not in the strict sense, certainly. Anyway, so as I said, 6-3 decision came down in favor of these parents who wanted to, have access to public funds for this purpose. And so basically the decision hinged on the idea as basically, as the opinion of the court stated, that you cannot discriminate against a school specifically because it is a religious school.
Right, because this could go to non-religious, non-sectarian private schools. So by crafting the law such that it denied private schools that were religious of the same thing that non-religious private schools were getting, well, that's discrimination against religion. Yeah. Just plain and simple.
Yeah, and there were noises that were made in the press and around the case itself about, well, the state wants to make sure that particular points of the curriculum are met, or that
that's a separate issue, though. They can still have standards that have to be met by any accredited school.
Right.
In fact, they could even condition. I don't know if the law was written this way, but many similar laws are written such that they condition the receipt of. A lot of times they're called vouchers. This is not technically a voucher program, but the condition the receipt of voucher money on adherence to certain state guidelines. Yeah, they can do that. That's not an issue.
Yeah, and I believe they did that in this case. I think more or less the only qualification was that the schools needed to be accredited and that they needed to be, again, non-quote-unquote sectarian. But, it was raised by the other side, though, that these sorts of funds were available for people who wanted to use Montessori schools or other sort of non-traditional models for schooling. Why should this be different other than that someone, again, and we talked about this.
Well, and it's a little crazy too, because presumably I could start a school and call it the Classical Education Academy that just wholesale copies and pastes the sort of Thomistic, Aristotelian approach to study, which is a very intensely Roman Catholic approach to learning, to education. But if I don't call it a Roman Catholic school, it doesn't matter that I'm using that method, that would be fine. It's specifically the identification with a religious institution that made it illegal under that law.
Yeah. I think it comes down to a very similar thing to an issue that we talked about in the case that involved the city of Boston. I forget what the other party's name was in that case. That was the other.
Oh, that's right. That was
free
the
expression
other one.
Case. I've forgotten.
Yeah, that was a sort of a gimme, like a.
Oh yeah, and I think
that one was really obvious how it was going to go, because that was the one where they said that every single other flag was fine to fly outside the Boston City Hall, except for a Christian flag.
Yeah. Basically what it came down to in that case was someone saying the fact that you want to use this flagpole to display a religious symbol would innately entangle the city in endorsement of religion, and therefore we can't allow it. Seems like
which is just such, I mean, just think for a second, that's such a strange way of running our country.
Yeah.
That, basically if there's anything religious that touches anything government, that's forbidden.
Yeah.
It's not about the government actually saying something that would lead a reasonable person to, which is that's Senator Day O'Connor's test, by the way, is whether or not the affirmation is something that would lead a reasonable person to believe that the government was endorsing a particular religion, which, I've got my criticisms of that test, but for all its faults, even under that test, there's just no way.
Yeah, but I forget who you quoted, but you quoted someone to the effect, might have been actually Justice Gorsuch, now that I'm thinking about it, and you can correct me if I'm wrong here, but someone said basically, the reasonable person test in the case of religion comes down to imagine a person who's as grumpy and anti-religion as you want him to be. And then
that was great.
Think about how
he's offended at everything.
Yeah. Think about how mad he might be if he saw something like this.
So not rather than a reasonable person, it's a particularly ornery anti-religious person who views everything as an affirmation or endorsement of certain causes.
Yeah. And I think basically the same sort of train of thought must have been going through whoever designed this program's head in Maine, whatever group in their legislature.
Well, it's because of the Lemon Test. It's just so many jurisdictions designed laws looking at the Lemon Test and saying, gee, we really don't want to provoke lawsuits under Lemon. Because remember, we talked about the 3 prongs of Lemon before. I don't want to get too much into detail today into those. Yeah. But it's excessive entanglement with religion. Neither advances nor inhibits religion. Very, very vague stuff. Things that you can read virtually anything as being a government endorsement of religion under Lemon. And they didn't want lawsuits. They knew those lawsuits would likely lose, but cities don't like being sued. States don't like being sued. So they tended to craft laws in such a way that they were really taking Lemon into account. So now that Lemon's gone, they don't have to do that anymore. That's kind of nice. Yeah, I'm guessing lots of people will still try to craft similar sorts of laws for other reasons, whether just inertia or otherwise. But, I think it's now very likely that they will lose all those challenges even earlier and harder than they often did in the past. But yes. A couple of things I want to note before we move on, and we probably should shortly here because I'm guessing we're probably going to go a bit late on the French Revolution part of this episode. But we're going with metric hours. Metric hours are a little bit longer. That's more than twice as long. As regular ones. Because it's 10 hours in a day. So we'll keep this podcast under an hour if you're measuring under the continental system. They don't keep using that. We can just call it They use the same system. They just threw out part of it. Well, all right, fine. Scientists today, the metric system scientists today use is the same system. They just took out the parts that we rely on daily because it became apparent more quickly that those didn't work well. Well,
Yeah. All right. maybe we should do a bonus episode that you can just air all your grievances with the metric system.
Because the whole point of the metric system is a calorie is what heats 1 cubic centimeter of water by 1 degree. Oh, and a cubic centimeter of water is the same thing as a milliliter. It's supposed to all convert across the entire system. So they just ad hoc took parts of it out.
As I said, maybe a bonus episode where I won't say anything. You can just talk about the metric system to your heart's content.
I'd love that, David. I would love that.
And then we will release it.
I'm not a big fan of the metric system. I measure in feet because I have feet. I don't have meters.
We will release that episode to no one. And
we could put it on Patreon. We could have a paid access.
Yeah, if someone wants to pay $10,000 to hear you rant about the metric system.
Yeah, there's got to be an exact interval of 10, though. They can't pay any.
Yeah, metric money.
Yeah.
Anyway, before we get into all that, to try to stay somewhat on task here, Justice John Roberts wrote the opinion of the court, and I did not read all of the dissent, but he mentioned this part of the dissent.
So this is a lot better than his opinion in Sibelius that we talked about, right? Remember, that was on our Hall of Shame a couple of weeks ago.
Yeah.
He doesn't always get them wrong.
No, but apparently the dissent argued that states should be free to pursue and have as an objective of their laws greater separation of church and state than the Constitution itself requires. And Robert's response to that was, okay, maybe, but are we going to call that a compelling interest, which would have been required?
That's
in this
also,
case?
In a vacuum, if you were just looking at the Establishment Clause, yeah, that's true. But there's another clause right next to that.
Yeah.
Called the Free Exercise Clause. And they aren't allowed to violate that. So, yeah, they can have greater separation between church and state than the Constitution requires. That's totally fine. But it can't run afoul of people's rights to freely exercise their religion.
Yeah. As I said, we've been talking, well, not on the podcast, but in our other materials, we've been sort of focused for a little while now due to some of the cases we have on issues of public education. And, I think it's worth noting that it's important to pay attention to what the public schools do, how they approach certain issues, because there's this sort of vague assumption that I think a lot of people have that whatever is going on in a public school is going to be neutral in some fashion.
Yeah.
And
just the facts.
Yeah, and that is a dangerous assumption for a number of reasons.
That's a very French assumption.
Yeah, and at some point, well, actually, yes and no on that point. Actually,
yeah, fair enough.
I agree with you on at a certain point in their history. Yes, that was the case. They've actually more or less recognized that they still do, in fact, have a state religion. It's just that their state religion now,
state secularism,
is secularism.
Yeah.
And
well, I'm talking about the French Revolution period where the goddess Reason was,
arguably that's
installed
not,
at Notre Dame.
Arguably, that's sort of intrinsically non-neutral either. If you're saying not only are we going to be reasonable, but we're going to worship reason, where we used to have a church.
Yeah, but you would think. You would really think that anybody who says that would recognize that's not a neutral position.
Yeah.
Their rhetoric to me suggests otherwise.
Yeah, but so, many listeners are probably going to remember, at least vaguely, that France implements certain policies, makes certain decisions that sometimes make the news, basically clamping down forcefully on people's religious expression in public places. They tried to ban Muslim women from wearing certain kinds of like full body swimsuits because that's a display of religion that's contrary to French values, and they have to wear bikinis. Or,
a secular person would never do that. We have state secularism, so you can't do it.
Yeah, or forbidding students from wearing either head coverings if they were Muslim kids in schools, or a crucifix if it's too big and too ostentatious. This sort of thing crops up periodically, and it's because they have as basically a positive principle of their society that you need to avoid religious display actively.
And
it's not enough.
I do think that's how for lack of a better way of putting it, how the liberal wing of the Supreme Court tends to view our Establishment Clause.
Yeah. And,
is if we can't have an establishment of religion, well, that means that we have established
irreligion.
I don't want to say, because it's not as strong as the French position, but a sort of a soft secularism.
Yeah. At some point, I'm guessing we'll probably go through specific parts. I'm sure, if we do this podcast long enough, we're probably going to end up doing episodes on different clauses in the Constitution and in the Bill of Rights and so forth. We'll probably end up talking specifically about the First Amendment at some point, but suffice it to say for now, that's
probably a safe bet. First Amendment's a big one.
But suffice it to say for now, though, that is just not at all how the framers of the Constitution would have understood the First Amendment to work.
And anyway, it's no information is neutral. Everybody has an agenda. They may not even know what that agenda is, but everybody has a perspective, and that perspective is going to bleed through into what they're doing. We actually have a really great video coming out on this. It's been coming out for a little while. It's taken a while in the editing process, but that's one that David wrote. That's going to be a really good one. So keep your eyes out for that. I think it's called, what is it called, David?
Well, the title will probably change because I couldn't think of a good catchy one. But basically, watch
State
out
as an interest group, I think is what you called it, right?
Yeah, and that's probably not what we're going to publish it under. But keep an eye out.
Because everybody's an interest group.
Yeah, keep an eye out.
Everybody has interests. Nobody is completely disinterested.
Right.
Keep that in mind when looking at information. Anyway,
exactly.
That's this case. Anything else to say about that case, or do you want to move on to the next subject?
Even if I do have more to say, we should probably move on because we don't want to be here all night and we don't want to make these people suffer through another.
There's a lot of issues we've hit before. That's why we tended to stray a bit on that one. Yeah, how disappointing has that got to be? This would have been a huge case in any other Supreme Court term. I can't imagine. Yeah. For the lawyers that brought this case, they got to the Supreme Court on an issue that's of major national import, and there's 3 others on the same issue, the same term, all of which are more important. By the time they hear yours, Lemon's already been overturned.
Yeah. So at best, the most notoriety that came out of this is I think it probably inspired a few extra people to tweet something about how the Supreme Court is trying to gut separation of church and state, which is pat nonsense. But
nonsense.
Anyway.
Yeah. And it's, to be clear, I think probably people on the more right-wing end of things tend to think separation of church and state. They like to repeat, that's not found in the Constitution. That's found nowhere in the Constitution. It's an unconstitutional concept. It's only in Thomas Jefferson's letter to the Danbury Baptists. That's absolutely true. It is not found in the Constitution. However, I think the concept of separation of church and state is actually a very constitutional concept. I think it sort of underlies the Establishment Clause of the Constitution. I think the mistake that those people are making is actually the same mistake people on the left are making. They're essentially treating the words religion and church as synonymous.
Yeah.
Separation of church and state does not mean separation of religion and state. Separation of church and state refers to institutional separation of the two. That the Roman Catholic bishop is not going to have an automatic position within our government. That somebody in our government doesn't automatically get to be a pastor of a church. Those things are separate institutions. Churches are one building totally separate from the government. Government's in a totally different building, totally separate from the church. That's separation of church and state. Nothing to do with separation of religious principles and state. Yeah. Anyway, that's sort of the broad takeaway for First Amendment religion clauses. I don't know why that's so misunderstood, but that's worth correcting before we move on. So now, at this point, moving on to Declaration of the Rights of Man and of the Citizen.
Yeah. And so before we get into that document proper, I think a little bit of historical background is probably necessary. And there's tons here. This is obviously a massively important event in the history of the world, if for no other reason than the French weren't content to have their own revolution without trying to make everyone else in Europe have their own revolution afterward. So huge fallout from all of these things. But to keep it very quick and basic.
It's to the point where the vast majority of the modern world, at least politically speaking and legally speaking, can be traced back to the French Revolution in some form or another.
Yeah.
It's one of the most, if not the most, significant political events in the past 500 years.
Yeah. Anyway, so to sort of set the stage briefly, there's a few things I think are important to know. One is that, we talked before about how what is called the British Constitution is mostly unwritten. There are some written documents that are part of it, but in large part, it's sort of just the acknowledged traditions of British law and government. In France, you basically don't even have that. People will talk about whether or not something is constitutional occasionally, but by that they mostly just mean nobody remembers it not being this way, so you have to do it this way. And that leads to just sort of a lot of
It's like saying it's against my constitution. You know, if you're overweight and read a lot, maybe it's against your constitution to run. That's sort of the way that it works in France. It's against their constitution to do certain things.
And the monarchy, despite, the fact that it struggled at the time in France to actually effectively impose its will in theory, and, in certain circumstances, it remained an absolute monarchy. So, for example, they had, sort of regional high courts.
But you're saying they're an absolute monarchy today?
No, I said at the time, didn't I?
Oh, sorry, I must have missed that.
Okay, yeah, no.
Because I think they just got a pretender today. I don't think that they recognize a king at all.
France is not a monarchy of any sort.
No, they're a republic.
Yeah, the what is it, 6th French Republic, 5th now? I forget.
Yeah, they've get a new one all the time. It's we're kind of embarrassed of our old crummy republic. It's still 250 years old or whatever it is at this point.
Yeah, whereas the current
we want
French...
a shiny new one, right? So people are trying to do that. They're trying to call an Article 5 convention. I actually had a call today from somebody who was interested in getting our legal work on a possibly illegal organization that's trying to have an Article 5 convention, because people really don't like how old our Constitution is. But
wow, interesting. Yeah, but I think that the current French system is basically dated to like the 60s, more or less. So, after World War II, you have what they called the de Gaulle years, when Charles de Gaulle was effectively sort of running the show. And then when he was off the scene, they were like, oh, well, we need to figure something else out. So
no monarchy. It was restored for a little while after the French Revolution, but then they got rid of it again.
Several
times. Back and forth quite a bit. Back and forth quite a bit. They had an emperor for a little while. You might have heard him. His name was Napoleon Bonaparte. Yeah. But we're a couple times, actually. We're going back before that, way back, all the way to 1789. So what's the world like in 1789? Well, obviously, the United States has just had its War of Independence. We concluded that independence occurred in 1776. July 4th, 1776, a date that you may have heard of. And we end up getting rid of our Articles of Confederation, drafting a new constitution at the Constitutional Convention in the summer of 1787, ratifying that in 1789. So right when we're getting our Constitution, the world is being thrown into upheaval in France.
Yeah.
And the world will never look the same afterward. I mean, Edmund Burke famously declared that the age of chivalry is gone, that of sophisters, economists, and calculators has succeeded, and the glory of Europe is extinguished forever. So we're going to look at the documents that accomplished that glorious task today.
Yeah, and so one of the things to bear in mind here is that this is a Declaration of Rights that is adopted by a body that calls itself the National Assembly. Now, where did these people come from, and, who gave them the authority? Those are sort of messy questions even to them.
Well, those questions are very simple in the United States. Exactly where our delegates to the Continental Congress got their authority. Exactly where the delegates to the Constitutional Convention got their authority. Very simple questions to answer. So already we're seeing differences.
Yeah. So in France, basically, leading up to this is in massive debt from mostly from a bunch of wars that they're trying to run, but also from the king maintaining an absurdly lavish court and nobody really being especially productive economically in France at the time for various reasons.
Those ortolans will cost you.
But anyway, so, everyone is basically saying we need to get something figured out to do this. The king is not in a very strong position, so he agrees to call what they called the Estates General. That was sort of this thing that people have heard about in France, but it hasn't been called for like hundreds of years at this point. They're not entirely sure how it's supposed to work. But the basic idea is that representatives of the French people are supposed to gather together, and they're divided into 3 orders: the nobility, the clergy, and the people, basically. So those 3 groups are
and those are the estates. You probably learned about that in history class in high school. There's 3 estates.
Yeah. And
first estate, second estate, third estate.
Right. And so those people all gather together, and they're going to, try to figure out what to do about all the problems that France is facing. And they show up, and basically the representatives of the people, the third estate, the commons, as it were, they say basically everyone needs to join us. In fact, none of the rest of this has any legitimacy. It's only the third estate that matters. And with a lot of pressure, including a lot of mobs in Paris working to make that happen and some other stuff behind the scenes, it does, basically. And they declare themselves the National Assembly. Now, everyone has been lumped together into the National Assembly, kind of by force. But one of the first things, I'm reading a book right now on the French Revolution and the history of the French Revolution, and I found this fascinating. One of the first things the National Assembly did is vote to free itself from any binding mandates that had been imposed upon the representatives when they were elected. So, people being chosen to go to this thing and work everything out. They, their electorates sent them with lists of things that they were supposed to do, and authorizing them to vote on these issues, but not only these issues. Basically, they show up and their first vote is more or less, none of that matters. We're just going to do whatever we want to now.
That's horrible.
We're starting off great already.
It's hard to come up with a better example of something that exceeds prerogative or is illegal than altering your mandate as soon as you arrive at a convention. And so I got to get this out of the way, because there are people who claim that our framers did that at the Constitutional Convention. You hear people say they were sent to revise the Articles of Confederation, and instead they voted to throw the whole thing out. That is not true. They were sent to come up with suggestions for fixing the Articles of Confederation. Suggestions. They were supposed to come back with something to suggest to the states.
Yeah.
And they didn't have to alter their prerogative at all. They came back with suggestions, and their suggestion was we ought to replace the existing articles with this Constitution. Then states called basically a plebiscite, and they appointed ratifying conventions in those states. Those ratifying conventions then were what looked over that Constitution and decided whether or not it was going to become law.
Yeah.
Constitutional Convention had nothing to do with that. They didn't exceed their prerogative in the slightest.
Yeah. Very much not the case with the French National Assembly.
So, pretty opposite.
Yeah.
And but you're seeing already, it's people, what in fact happened in France gets retroactively read into what happened in the United States.
Right.
Such that people start to see commonalities and parallels between the two, where they really are totally different.
Yeah. And anyway, to that end, we should probably read now the text of the Declaration of the Rights of Man. And
can you do a pretty good fake French accent, David?
I'm not going to. Whether I can or can't, I'm not going to.
Oh, mine's no good, but I would do it if I could do it.
You shouldn't. Because this is actually, it's not a super long document, but it is kind of a long document. And I don't think anyone wants to hear that for that long. Anyway, I want to point out.
By the National Assembly of France.
Oh, please don't. Please don't. Before we actually get into it.
I told you it wasn't good, David. That's what you're asking me to do by not doing it yourself.
No, I explicitly asked you not to do that. But before we get into the actual document, I want to remind people that very often this is treated as a parallel to the Declaration of Independence. I think mostly because they both have the word declaration in the name. But you'll see if you listen to our previous episode.
Right.
If you listen to our episode on the Declaration of Independence, I think it should become obvious very quickly that these are hugely different documents. There's a bit in the very beginning of the Declaration of Independence that sort of sounds like some of this, but after you get past like the first paragraph, there's basically nothing in common at all. And with that in mind.
Yeah. And it's Governor Morris, actually, the ambassador of America, would talk a lot about how people were really enthusiastic about the fact that he was involved in American independence, but nobody listened to his advice at all.
Yeah.
So people that were drafting these documents were not consulting with the people who had written them in the United States. So, anyway, not consulting with people that wrote them, not really influenced by, except for to the extent of, hey, the Americans were able to shed themselves of their overlords, maybe we could do it too. Certainly they were influenced in that way. But the thought, not as much. So anyway, let's jump into it.
Yeah. So it says, the representatives of the French people, organized as a national assembly, believing that the ignorance, neglect, or contempt of the rights of man are the sole cause of public calamities and of the corruption of governments, have determined to set forth in a solemn declaration the natural, unalienable, and sacred rights of man. In order
it used the word unalienable.
Yeah.
That's similar.
And it says something.
I see one similarity so far.
Yeah, it says something about rights. Actually, since we're paused, thank you for the interruption. Yeah. I do want to point out already you should be able to see one major difference here, which is that whereas the Declaration of Independence said we have a specific situation where our rights have been infringed, we have a specific sort of reason to be seeking a change. This is just already saying things that are true in general, or supposed to be true in general.
Yeah.
And that'll be a theme throughout. And, we'll get more into that later. But this, for a document that was supposed to sort of kickstart a new form of government, there's remarkably little that is sort of legally applicable or of any practical import here. But we'll get into that more later. So,
well, that's because the French are not nearly as uptight as descendants of Englishmen. It's it's whatever goes. It's fine. It'll work. We're like, no, we want it spelled out. We want it point by point.
Interesting to say that they're less uptight when shortly after this they're going to be chopping people's heads off by the dozens, if not hundreds. But
oh yes, but casually, very
very sort of blasé about it.
Yeah, it's not a big deal or anything. It's just that we inspect everybody going over our borders and make them present papers and you cut their heads off to the cries of the rabble when they're people we don't like.
Yeah, you can picture the executioner leaning against the guillotine and smoking a cigarette while he does it. But
that's exactly what I was picturing. That's just the way that Thomas Carlyle described it.
Anyway, so in order that this declaration, being constantly before all members of the social body, shall remind them continually of their rights and duties, in order that the acts of the legislative power, as well as those of the executive power, may be compared at any moment with the objects and purposes of all political institutions, and may thus be more respected. And lastly, in order that the grievances of the citizens, based hereafter upon simple and incontestable principles, shall tend to the maintenance of the Constitution and redound to the happiness of all. Therefore, the National Assembly recognizes and proclaims in the presence and under the auspices of the Supreme Being the following rights of man and the citizen. So that's the preamble.
So they're saying explicitly this is not law. This is just so that the citizen can look at this and then compare it against what the government's doing as sort of a, like those paint palettes that Pantone makes, where you hold them up to your wall. It's like, how much has the wall faded?
Yeah.
You're supposed to hold this up to your government and see how much has it faded from its purpose.
And if it's faded more than you would like, get the axes ready for some chopping.
Yeah.
Anyway.
You're going to need a paint mixer. And by paint mixer, I mean guillotine.
Yeah. So these are the rights that they declare. Number 1, men are born and remain free and equal in rights. Social distinctions may be founded only upon the general good.
Gosh, that language is similar to the Declaration of Independence, but there's zero implication in the Declaration of Independence has anything to do with social condition.
Right. There is not zero reason why people try to compare aspects of the French Revolution to what happened in America. There's not no reason. Men are born and remain free and equal in rights. Yeah, that sounds good. But there's a twist. I think that, there's always a twist to it.
What you've got to understand about this time period, really about any time period, and I'm sure you can think of examples today. I'm not jumping in mind for me, but in different times, people tend to use certain buzzwords, slogans, certain language tends to become very popular, enters very widespread use, regardless of where you fall on any kind of political, philosophical, religious, legal spectrum. You're going to express a lot of things using the same words, and you're going to mean different stuff by those words. I was just on a podcast earlier today where they were talking about sort of this concept. We're talking about diversity, equity, and inclusion. Now, just me saying those words, I think you already understand the concept that I'm talking about. Those words mean very different things depending whose mouth they're coming out of. So that's, I think, part of the confusion is that they were using late 18th century language, both of them, sort of Enlightenment language, but expressing very different ideas with it. Social distinctions may be founded only upon the general good. That's polar opposite of the Declaration of Independence. Declaration of Independence says that rights are derived from the consent of the governed, irrespective of the general good.
Yeah.
Rights come first. You organize your government such that it defends those rights, and then after that, you do it in the way that they think will be most conducive to their future safety and happiness.
Yeah, and that'll be a
social
distinction.
Social distinctions come way before that. That's a way lower order consideration.
Yeah, and that'll be a general pattern that I think people will be able to see is that the philosophical definitely takes precedence over the sort of question of legal rights throughout the French Revolution. But
not big fans of law. In fact, it's their courts are. French Revolutionary. If you've ever read Charles Dickens' Tale of Two Cities and seen the courts in that, it's a parody of how lack of procedure, particularly lack of rules of evidence, how the French rule of guilty until proven innocent, how this just makes a mockery of justice.
Yeah. Well, anyway, we'll have more opportunity to talk about that, but we probably do need to keep it moving. So I'm going to go on to number 2, which says, the aim of all political association is the preservation of the natural and imprescriptible rights of man. These rights are liberty, property, security, and resistance to oppression.
All right. Again, you can see a little bit of a parallel here.
Yeah.
But aim of all political association is the preservation of these unalienable rights. What did the Declaration of Independence say? Government. Governments are instituted among men to preserve these rights.
Yeah.
Not all political association. Because there's a lot of political activity that has nothing to do with state power and state coercion. You know, we have Rotary clubs. We have all kinds of stuff.
Clubs, for those of you who remember your history here, clubs, actual literal clubs for people to come and talk politics and debate philosophy and stuff, are a huge factor in the French Revolution. So
yeah, particularly the Jacobin Club.
Yep, them especially, but there were others as well, less successful than the Jacobins. But all right, anyway, number 3.
Yeah, I mean, the fact that a club ends up holding political power, it shows that clubs were kind of a big deal, even a bigger deal than they are in sort of the EDM scene.
Good one. I'm sure you've been to plenty of raves and know all about that world.
Not once, actually.
Oh, you're shocking.
Believe it or not.
I can't believe it. All right.
I know, right? You would never guess.
Number 3. The principle of all sovereignty resides essentially in the nation. No body nor individual may exercise any authority which does not proceed directly from the nation. The nation.
Okay, so maybe they did read the Declaration of Independence, because they're going through sort of the points in order and showing how strongly they disagree with them. Because the principle of all sovereignty resides in the nation. Well, what does the Declaration say about that? Declaration of Independence. The people.
Yeah.
Governments derive their just power from the consent of the governed. Individual people. This has exactly the opposite, that it does not derive from individuals, it derives from the nation collectively. That pairs very neatly with the from the first article about the distinctions being founded upon the general good.
Yeah. And
whenever you talk about things in a general sense, talk about the nation as a whole, talk about the general good, as opposed to the good of the individuals that actually comprise that thing, that is licensed to do whatever the heck you want, whether or not people like it.
Yeah, and we'll definitely talk more about that in a minute, so I'm going to hustle a little bit here. Number 4, liberty consists in the freedom to do everything which injures no one else. Hence the exercise of the natural rights of each man.
Gosh, the libertarian axiom right there.
Yep. Hence, the exercise of the natural rights of each man has no limits except those which assure to the other members of society the enjoyment of the same rights. These limits can only be determined by law.
Actually, even right here, you see the use of natural law is completely different from under a Scottish Enlightenment, English Enlightenment view.
Yeah.
By the way, we sell a copy of John Locke's 2 Treatises on Government if you want to understand his concept of natural law.
Yeah.
But this concept is very clearly different because they're treating natural law as essentially synonymous with civil law.
Yeah.
Saying that that's what political rights consist of. Where for John Locke, under the English, Scottish, American view of natural law are those principles which pertain to rights prior to the organization of any society.
Yeah.
Logically prior, not necessarily chronologically prior.
Right.
These limits can only be determined by law, it says.
Yeah.
That is, so they call it natural law. So when you use that term, generally people would think that those rights exist in nature, some way that's generally accessible to all people. That people can understand and apprehend that via their reason, right? That's not what they say here. These limits can only be determined by positive civil legislation.
Right. Because again, what really counts here is what the nation wants, and how you define the nation is obviously a problem.
We
here.
pick what constitutes harm to somebody else.
And
we think that being...
Yeah, they've already declared themselves the representatives of the nation. Remember, they changed the name from being the Third Estate to being the National Assembly, and then they promptly voted to free themselves from any mandates that bound them to the things the people who elected them actually wanted them to do.
And that's law now, because the limits of rights are determined by law.
Yeah. So the next one, basically, a flip side of that one, says law can only prohibit such actions as are hurtful to society. Nothing may
hurtful to society.
Nothing may be prevented which is not forbidden by law, and no one may be forced to do anything not provided for by law. So, the key thing to note there is that law could be anything under this model. Law can be whatever the National Assembly determines it to be. There aren't any, fundamental limits in what they've said philosophically.
No, it's got to be only something that prohibits things that are hurtful to society. David, that's a limit.
Right, but in whose eyes? Anyway.
The eyes of the nation. It said that earlier.
And the nation is us. All right, moving on to...
they represent the nation. They've appointed themselves to do that. Yeah,
anyway, we got to keep it moving quick, so I'm going to try to blast through some of this.
Sure, fair enough.
Right.
How many are there? Oh, goodness, there's 17?
Yeah. So number 6. Law is the expression of the general will. This is where we're really into the meat of it.
There we go. They were answering David's objection. See, they're on to you, David. They know what you were going to say, and they've got an answer for it. Law is the expression of the general will.
Every citizen has a right to participate personally or through his representative in its foundation. It must be the same for all, whether it protects or punishes. All citizens, being equal in the eyes of the law, are equally eligible to all dignities and to all public positions and occupations according to their abilities, and without distinction except that of their virtues and talents.
Gee, that reminds me, you know the step 3 profit scheme?
Yeah. Yep.
Step 1, I forget what step 1 is.
Collect underpants in the original.
Yeah, collect underpants. Step 2, question mark, question mark, question mark. Step 3, profit.
Yep.
Yeah, it is. Okay, I get it. Yeah, so all laws are the expression of the general will. Yeah, every citizen has a right to participate. Yeah, sure, that makes sense. So because of that, we're going to make sure that all dignities and public positions and occupations are available according to ability.
Yeah.
What's step 2? How do you get to that?
I think, the background here is the fact that prior to the French Revolution, there were certain official positions that were open only to nobility or only to clergy. And basically, one of the major grievances that people had going into the National Assembly was that they were barred from certain positions. And, understandably so.
So Napoleon was just the most capable Frenchman?
Well, he's not on the scene yet. You're anticipating.
Or Corsican, rather. I guess he's not even French.
Yeah, but we'll get to that later. But I think that for now...
So Robespierre is the most capable Frenchman.
We'll get to him sooner than Napoleon. But I think the key part of this one for us is that...
I like living in a country where I don't have to think of my president as the most capable American.
Yeah. But thus far, the key element in this... as far as everything else goes, is that expression law is that phrase rather, law is the expression of the general will. Because I think there's basically 2 accents you could give that. And on the one hand, you could read it as saying the general will should decide the law, and the law will be what the general will decides. Or the other way you could read it, and I think this is the way that ultimately wins, is what the law is the will of the people by nature, by definition. And therefore, anyone opposed to a law is opposed to the people. And that will have some ominous...
I think that's slightly unfair because I think they would only say that's true of a democratic government.
Yeah, no. Well, yes, law as they're deciding it, but things will sort of quickly slip from the grasp of the ordinary electorate of France, let's say.
Yeah, turns out the center does not hold.
Yeah. Anyway, number 7. No person shall be accused, arrested, or imprisoned except in the cases and according to the forms prescribed by law. Anyone soliciting, transmitting...
That sounds like, no prosecution without due process of the law. That sounds okay.
Yeah. Anyone soliciting, transmitting, executing, or causing to be executed any arbitrary order shall be punished. Now, this is where we get a little more questionable.
Oh.
Punished by whom and according to what system? But any citizen...
Any arbitrary order.
It goes on. But any citizen summoned or arrested in virtue of the law shall submit without delay, as resistance constitutes an offense.
We have that one now. We got that. We copied that one. Resisting arrest?
Sort of.
Yeah, we have that one now. We used to not have that one. That's because of this. So
anyway,
that's great.
We'll talk more about that in a minute. Number 8. The law shall provide for such punishments only as are strictly and obviously necessary, and no one shall suffer punishment except it be legally inflicted in virtue of a law passed and promulgated before the commission of the offense.
Well, you got no ex post facto law there. The second part, that's pretty good.
Yeah.
First part, I guess, is maybe designed to parallel excessive bails or cruel and unusual punishment.
I think, that's basically...
I don't know how you define a strictly necessary to what end for the punishment.
That's
strictly necessary to satiate the insatiable appetite for blood of your leaders, because
that's
happens,
a pretty
basically. High bar. But I would say that's a bar that they can probably meet most of the time.
Yeah. You see on the one hand, what the idea is. They're mad about sort of politically motivated punishments, which tend to go with arbitrary monarchies sometimes. Obviously, the English
have
their own experience with that. But who's going to decide what's strictly and obviously necessary?
No, they're asking don't be arbitrary, but they aren't providing an alternate standard against which you can measure it.
Right.
You could say it's strictly necessary to prevent the specific criminal from recidivism.
Yeah.
That's going to be hard to determine. That's going to require a lot of judicial discretion. That's going to end up being very arbitrary.
Yeah. Anyway, got to keep it moving. So number 9, as all persons are held innocent until they shall have been declared guilty. If arrest shall be deemed indispensable, all harshness not essential to the securing of the prisoner's person shall be severely repressed by law. Again, in principle, that sounds pretty good. You want to...
So when did they get rid of the innocent until proven guilty?
Well, we'll talk about that very specifically in just a bit, so bear with me.
Okay, this timeline, so much changed so quickly, I have trouble keeping track of when things changed.
Yeah. 10. No one shall be disquieted on account of his opinions, including his religious views. Sounds good so far, right?
Oh, that's pretty good. They don't do that anymore.
Provided their manifestation does not disturb the public order established by law. So
okay,
no.
So when that Muslim lady wore her burqa to the opera, like happened a couple of years ago, and then all of the audience, and I think the singers even and the orchestra, all shouted at her relentlessly until she left, you would say that she was actually in the wrong there, because the fact that they were very angry about her religious expression meant that she was disturbing public peace.
Probably, there probably wasn't a specific law against doing what she did, so maybe not. But if we bear in mind that the law is just the general will, seems like the general will was against her there. So yeah,
it
probably.
Seemed they generally willed that.
Yeah,
generally willed for her to leave.
Yeah. All right. Anyway, number 11, the free communications of ideas and opinions is one of the most precious of the rights of man. Yeah, that sounds good. Every citizen may accordingly speak, write, and print with freedom. Sounds good. But shall be responsible for such abuses of this freedom as shall be defined by law.
Ooh, you dropped the ball there.
Yeah.
That was, big swing and a miss on that one. You could have just put a period after and print with freedom. Yep. You didn't need to, and shall be responsible for such abuses of this freedom as shall be defined by law. How can you abuse a freedom?
Yeah.
If you're free to do something, by definition, you can't abuse it.
Unless the general will goes against you. And by general will, we mostly mean the Jacobin Club. But, we'll get to that. All right.
That's good. Big swing and a miss there. That's
a bad one. Number 12. The security of the rights of man and the citizen requires public military forces. These forces are therefore established for the good of all and not for the personal advantage of those to whom they shall be entrusted.
Oh, good to know. Yeah. Good to know.
And, to be fair, you have a long tradition of only aristocrats leading armies. Aristocrats often have their own agendas. You get what they're aiming at here. Does this need to be a fundamental political principle? I don't know. I don't know about that.
Well, it's also, you can say this.
Right.
But then when people do establish militaries.
Yeah. Who's going to stop them?
It's any man's guess whether or not they're going to be established for the good of all and not for personal advantage. My bet is they're probably going to be established for the advantage of whoever is paying them.
Yeah. And speaking of Napoleon, which we will probably be doing at length a couple episodes from now. They really failed to keep this one going. We can say that at the least. Okay, so moving on, number 13, a common contribution is essential for the maintenance of the public forces and for the cost of administration.
I don't like that one at all.
This should be equally distributed, equitably distributed among all the citizens in proportion to their means. So they have as one of their...
very different.
Yeah, one of their fundamental political principles is an income tax. That's
graduated income tax.
Yeah, not something that they, came up with later, which is what happened in America, but this is enshrined from the very beginning as one of the, not just a thing that's good and we should do, but as a right of man is to be taxed.
A right of man is a graduated income tax.
Yeah.
Not even that you'll be taxed, but specifically a tax on income and a graduated tax on income.
Yeah.
Wow. I'm not a big fan of that one at all, to be honest with you. Again, remember, we mentioned this when we were talking about Sebelius. That's the Obamacare, or as I like to call it, Roberts Care decision. Yeah. We mentioned that in the United States, prior to the 16th Amendment, any tax had to be imposed in proportion to the enumeration of the census of each state. In other words, everybody had to pay the same amount.
Yeah. Anyway,
very different.
So, quite different. Anyway, number 14. All the citizens have a right to decide, either personally or by their representatives, as to the necessity of the public contribution, to grant this freely, to know what uses it is put to, and to fix the proportion, the mode of assessment, and of collection, and the duration of the taxes. So, I guess if you're going to be taxed, you should have a say in it. That's true, I guess. But, we didn't need to
This reminds me of, I think I sent this to you, David. Mm-hmm. There's a Noam Chomsky video that is... probably one of the dumbest things I've ever heard.
I know which one you're talking about, yeah.
Where he says that if we lived in a truly everybody hates April 15th, obviously, because you pay your taxes. And Noam Chomsky says if we lived in a truly democratic society, people would love April 15th, because that would be the day when we get to fund all the things that we decided and that we picked.
Yeah. Yeah. So happy to pay the taxes that. But apparently, if you're French, that's true, or should be true, according to this anyway.
That's just the most out of only somebody who's been an academic for 60 plus years could think that. People are. I mean, even if it's majority rule on everything, presumably sometimes people are going to vote for things that you personally didn't like, right? Yeah. You're not just going to say, well, that's the will of the majority, so I love funding it now.
Yeah, but you should, though, because otherwise you don't like democracy.
Yeah, they truly, even if they don't think they love it, they're in their true heart of hearts, they actually love it.
Yeah. Number 15, society has the right to require of every public agent an account of his administration. Yeah, I mean...
That one's good.
Sure, yeah.
It's like a public records section. Yeah, that one's good. I don't have any qualms with that one.
Yep. Number 16,
I guess it doesn't specify a method, but none of these are very specific. So
right, and that's that'll be one of the touchstones of our discussions of the French Revolution. Number 16, a society in which the observance of the law is not assured, nor the separation of powers defined, has no constitution at all.
They never had separation of powers.
Right, and they talk about separation of powers, but then their actions speak much louder than their words, as we will talk about at least in future episodes, if not today.
You know what's amusing to me? Mm-hmm. There was nothing in any of these articles saying that a society must have a constitution, or even that a constitution was good. So that's true. All this article is saying is that, well, if we don't do these things, then we don't have a constitution.
And
that might be fine for all we know.
That could be good or bad. Who knows? Anyway, all right. And finally, number 17, since property is an inviolable and sacred right, no one shall be deprived thereof, except where public necessity legally determined shall clearly demand it, and then only on condition that the owner shall have been previously and equitably indemnified.
Wow. This is another one where you can see the way that this absolutely colors the way that people interpret sections of our Constitution. Yeah. We have no property shall be taken except for public use. Yeah. But if you look at the Supreme Court precedent on that over the past 200 years or so, it's not public use at all. I mean, they'll very regularly take private property. Well, for instance, I live in Los Angeles. They took private property to build Dodger Stadium. Yep. Dodger Stadium is not public use. That's used by the Dodgers.
Right.
But you can see where this language of public necessity has colored the interpretation of what our documents say, which is something very different.
Yeah. Well, and like I said, I've been reading a book on the history of the French Revolution lately, and it's made me remember an instance that they talked about where, very shortly after the National Assembly gets going, there's a huge grain shortage in France. They're having, they're on the back of several bad harvests in a row. And, traditionally in France, as was the case in many other countries around the world at the time, when food is scarce, the government starts imposing price fixing on bread. And interestingly, a lot of the members of the National Assembly were, up to this point, opposed philosophically and politically to price fixing. But they're suddenly in Paris where there's mobs of very hungry people very mad at them and wanting cheap bread. And so they basically sanctioned people going into bakeries and grocery stores, grabbing all the merchandise, selling it to the crowd outside at what they have just determined to be a fair price, and then handing the money afterward to the owner. And that flies very much in the face of this last part.
Public necessity.
Well, yeah, public necessity.
Previously and equitably indemnified, not subsequently. Yeah.
Previously indemnified, not.
Well, indemnification just means that you promise to cover their liability, not that you actually.
Well, yeah, but I don't know that there was much of a time.
So maybe they told them when they took it, we'll pay you back later. Yeah, that would be an indemnification.
Previously, by the span of 5 seconds. But anyway, so
yeah, that's previously.
This was the Declaration of the Rights of Man. Now, we've gone through...
I can't say that I like it.
No, we've gone through and we've highlighted some of the specific differences between the American system and what's contained here. But I want to return to this idea that we really emphasized when we were talking about the Declaration of Independence. The Declaration of Independence is basically a legal complaint. So it cites specifics. It says these things happened. These rights were violated in this specific way. And therefore,
these are our rights. Yeah. Here is how our rights have been violated. Here is the consequence for the violation of our rights.
Right. Whereas here, you get nothing but broad and sweeping statements on the one hand, and then on the other, reading between the lines, pretty specific, like ultra specific things that actually don't apply to most circumstances in general, mainly to do with people being mad at the nobility. So I think it's an interesting contrast on that level.
Yeah, it's remarkable how well the grievances in the Declaration of Independence have aged, actually, because their specific grievances very much tied to that historical period. But because many of our founding fathers were so well versed in political theory and philosophy, they studying back all the way to Cicero, Aristotle, the sorts of patterns they were looking for were ones that are repeated in governments. So it's not just, we're mad at the particular administration right now, even though it is the grievances they've committed. It's the sorts of things governments tend to do as well. Yeah.
Anyway, so that's the text of the 1789 Declaration of Rights of Man and the Citizen. Less well known is an edition that was voted on 4 years later. It was approved. It was meant to be part of the project of establishing a new constitution for the French Republic.
Yeah.
But
this is the one that I believe Governor Morris was commenting on, this constitution.
Yeah. But it never actually ends up getting used because shortly after the new constitution is approved, it is suspended by a declaration of emergency, and emergency powers are given to what was called the Committee of Public Safety. And they're
that sounds good. They keep you safe.
They're the ones who are going to be guillotining people and eventually will be guillotined themselves because revolutions eat their own. But
those who have nothing to hide have nothing to fear.
Yeah.
It only exists to keep us safe.
Yeah.
Don't you care about safety?
No, not at all.
That's actually Benjamin Franklin's famous quotation that those who would sacrifice liberty for security deserve neither and will lose both is a direct reference to that.
Yes. And we're not going to read all of that 1793 version. For one thing, it's substantially longer. For another, it has a lot of the same things, but it does have a lot that's quite different. But I do want to just sort of highlight a few specifics. So talking about the same sort of concept that we saw in the original version about basically protections against arbitrary arrest, they say, no one ought to be accused, arrested, or detained except in the cases determined by law and according to the forms that it has prescribed. Any citizen summoned or seized by the authority of the law ought to obey immediately. He makes himself guilty by resistance. So we're getting a little more explicit about
guilty of the crime that he's accused of, not just guilty of resisting arrest?
Just guilty in general. And, as you can probably guess, being found guilty by the revolution at this point tends to be very bad for you.
Oh, let me get a guillotine sound effect. I don't have time. Go ahead.
Yeah, it's fine. So there's that.
We should have that for the rest of this series, though.
Fair enough.
Just punctuate transition with the guillotine sound effect.
Fair enough. Another key difference here is that whereas in the original version, it said that men are free and equal in their rights, the 1793 version adds that they are equal not only before the law, but by nature. And reading between the lines, this is where we're starting to get to the point where basically the Paris mobs are really calling the shots behind the scenes. And if you're equal by nature, not just by law, then any differences that you can sort of notice are suspect, right? Because if everyone's equal not only in their rights, but also by nature, why is anything different for anybody? So suddenly...
aren't we? Our Declaration of Independence says all men are created equal and endowed by their creator with certain unalienable rights.
Yeah, created equal, but equal in what capacity is the question here.
Equal in their rights. I mean, that's the next clause of the sentence.
Yep. And so suddenly, you're a rich man. Why are you rich when other people are poor? And you can see...
They don't specify what sort of equality they're talking about.
Yeah, but
it's not just equality before the law. It's equality as a general proposition.
Right.
And that's from Rousseau. That's directly from Rousseau. Everywhere man is born free, and yet everywhere he is in chains. That's very much Rousseau's state of nature. He's sort of where we get the idea of the society is what creates these distinctions among men.
Yeah. Here's another one. I think this one you'll see immediately where the problem is. You, Alex, specifically, hopefully the listener as well, but they added
a hot take?
A new clause.
Because I've not read this one before.
No. They add a new clause. Well, it could be a hot take of sorts, but they add a clause that says, a people has always the right to review, reform, and to alter its constitution, which, thus far, okay. But one generation cannot subject to its law the future generations.
Oh my gosh.
So basically,
You hear people saying that all the time nowadays.
yeah, and this is where that idea probably came from.
That's the worst. That's one of the dumbest things I've ever heard.
Yeah, now,
One generation necessarily subjects the next generation to things. I mean, the mere fact that you were born to certain parents subjects you to things.
yeah, and while it sounds, there's a certain kind of anti-authoritarian, pro-freedom and pro...
Don't trust anyone over 30.
Yeah, well, there's a certain angle where you're like, yeah, that makes sense. You know, why do I have to listen to what you told me to do just because you told me to do it? But the problem is, a society's laws are transpersonal and transgenerational. They are there to...
Well, because there are legal relationships that are created by the law. And those exist over spans of time.
And the point of it is to ensure that there is a stable and predictable environment for you to go about your life. And
here's a great example.
Mm-hmm.
In the United States, there are two different basically legal regimes that apply, depending which state you live in, when it comes to marital property. And that applies at divorce, that applies at death and inheritance a lot of times. But those are the common law rules of marital property and what's called community property rules of marital property. Why do we have that? Well, it's because some of our states began as English colonies and some of our states began as Spanish colonies. And if people are married under Spanish law, which treats their property a certain way, very differently from how English law treats it, those marriages aren't going to go away once those states are incorporated into the union. Those marriages are going to continue to be in effect. You can't throw all those people who are already married into upheaval as a result of this new legal regime that's come into effect. Yeah. So, because of that, to this day, we still have essentially Spanish rules for marriage in many states. California is one of them. Mm-hmm. And you can't ever get rid of that because there's always, any date, pick 20 years from now, we're going to get rid of it. Well, there's going to be people married at that point that may spend a great deal more of their life married afterward. There's never going to be a point at which you can have complete separation between the old regime and the new one.
Right.
Because there's never going to be a point where nobody's married and then all of them are getting married again afterward.
Yep.
Now, some countries don't care about that.
Like France.
Yeah, they're fine just throwing people's pre-existing and legally defined relationships into upheaval. We don't do that here. We like contracts to be upheld. We want people to have expectations of the way the future is going to work. We don't want to change things on people. Yeah. Reliance interests, we talked about this in the Dobbs discussion. That's the case that overturned Roe v. Wade. And we said that probably the strongest thing against overturning Roe v. Wade was what's called reliance interests.
Yep.
People had to plan their lives around a right to abortion. And while I don't think that was strong enough to go against overturning Roe v. Wade, reliance interests are a very strong consideration in many, many cases. It's a significant thing. And I think France just apparently doesn't put much value on that at all.
No. And anyway, there's more to this one that we could talk about, but for the interest of time, I just want to bring up one more. And for this one, we need to, again, return to a little bit of historical context. In January of 1793, a very particular person goes to the guillotine, Louis XVI.
More particular than other people.
Well, in a sense. But Louis XVI, who at this point has been formally deposed, so they don't address him in court as Louis XVI. They call him Louis Capet, which is a very old family name for the French royal dynasty. But they put him on trial. They execute him in January. 6 months later, in July, they adopt this document. And one of the things it says, let any person who may usurp the sovereignty, and they've, the previous clauses have been about how the sovereignty lies with the people, but let any person who may usurp the sovereignty be instantly put to death by free men. Instantly.
Okay. Instantly.
Mm-hmm.
I'm not comfortable with that at all.
As to your question about when do they get rid of innocent until proven guilty, pretty much here, because this is what...
Well, I'd say it's solidly gone by this point. This is not the first step in getting rid of innocent until proven guilty.
But let me read you, and this is the leading voice of what has become the rising power of the French Revolution. This is Maximilien Robespierre, who would go on to lead the Jacobin Club, lead the Committee of Public Safety, until eventually people got tired of being tyrannized by this man and they put him to death. So
they call it the Reign of Terror.
Yeah. But
and it's called that for good reason.
This is what he had to say about the trial and execution of King Louis. Louis cannot be judged. He has already been judged. He has been condemned, or else the Republic is not blameless. After all, if Louis can still be put on trial, Louis can be acquitted. He might be innocent. Or rather,
that's the point.
He is presumed to be until he is found guilty. But if Louis is acquitted, if Louis can be presumed innocent, what becomes of the revolution?
Oh my gosh.
Mm-hmm. I almost decided
that reminds me of that governor, or was it the mayor of Chicago?
I'm glad you brought that up, because I was about to say I almost put this one in the hot takes, and I was gonna ask you to see if you could think of any parallels with this. Lori Lightfoot, she said that if someone has been arrested and held in a jail awaiting bail for a violent crime, that they shouldn't be bailed and released back into the community because the prosecutor must have enough evidence to actually convict them if they would have arrested
Yes, they're innocent until proven guilty. Yes, we understand and accept all that, but if the prosecutor arrests them, they're guilty.
But this, speech by Robespierre, obviously this isn't all of it.
That is that is absolutely stomach turning.
Yeah, I think, it literally caused chills. Like I said, I've been reading this book, and I got to this part of it, and the hair on my arm stood up when I read this part. Because you can see already what's happened, which is the revolution itself has become the source of all legal legitimacy. And who is part of the revolution? Basically, whoever is able to impose their vision of the revolution.
But it's insane that he even recognizes that's what's going on.
Yep, and he's open
because he says the revolution has failed if we don't find Louis guilty.
Yeah, and so therefore, irrespective of whether he is guilty or isn't guilty, and the charges against him were...
The fact that the revolution took place means that Louis is guilty.
Yeah, because if we say that he might not be, not even that he is innocent, but that he might be innocent, then the revolution is over instantaneously.
That is, I'm beyond words.
Yeah, it's wild. So we'll talk more in future episodes about the direction the revolution takes. But I want to point out too, as we talked about, there are plenty of reasons to be critical of the original statements of the Declarations of the Rights of Man that came in 1789. 1793 is... that version of it is, you can see where the tracks have been laid and where the train is heading. And it's pretty
that's where
upsetting.
That's where Edmund Burke made his, I think in 1793 is when Edmund Burke made his famous quotation. Yeah,
I think that might be right. But
Edmund Burke's a big hero of ours over at Lex Rex. So
I have to quote him. At any rate, we see the degeneration, how quickly it comes. It starts as something that could have resulted in reforms basically in the way that public officials were chosen and how people would have input into the laws of France. And
very valid grievances.
Yeah, and it ends with basically an explicitly, dictatorial system where the revolution itself, whatever the internal logic of the revolution is, doesn't matter who voted for it, who's in favor. If the revolution is going one way, that's what's right.
A complete abandonment of the rule of law.
Yeah. All right. Well, and I think I've commented on this before, but sometimes the transition from our final topic to hot takes is very jarring.
That's a good one, because that Robespierre thing would have been a great hot take.
Yeah. Well, if I had,
I want to just conclude this section. So we would loathe to just sort of force feed you guys opinions, but we'll let you judge for yourselves whether or not the French Revolution is very similar to American independence.
Yeah.
Hot takes.
Hot takes time. Here we go. Okay. So this first one I picked because it has a lot to do, or, at least parallels with the case we talked about earlier, that case in Maine. So without further ado, here we go.
This is from Twitter again, David. You promised me they wouldn't be from Twitter today.
No, well, one won't be. Two will be.
One won't be. All right.
Yeah.
I'll take what I can get.
Yeah.
Okay. So this is, I guess, a facetious exchange between people.
No. This is just a list with it's just this.
Oh, just a list of people with things that are true about. Okay. Yep. So this is from Jeff Blackwell. He says, John Roberts, Catholic. Clarence Thomas, Catholic. Samuel Alito, Catholic. Brett Beerboy Kavanaugh, Catholic. Neil Gorsuch, Catholic. Amy Barrett, Catholic. The U.S. is only 2/9 Catholic. This is what a religious test for office looks like, prohibited by Article 6. Okay, well, first of all, Justice Gorsuch is not Roman Catholic.
Yeah. Well,
Justice Gorsuch, I believe, is Anglican.
There's sort of an ambiguity about him because I believe he was baptized Catholic and raised Catholic.
He was raised Catholic. His mother was Roman Catholic.
Yeah, and he may not have ever. You have to actually go out of your way to remove yourself from the roles of confirmed Catholics. So maybe he never did that, but as far as I know, he attends an Episcopalian
I guess
or Anglican
you're
church.
right. The Roman Catholic Church would still consider him Roman Catholic.
Yeah.
That just probably wouldn't be how he identifies himself. Okay, so that's fair. They can say that, but that's not what he would consider himself. All right, so leaving that factual error aside, also the epithet of Kavanaugh as beer boy is not one that I've heard before, but
I think he made it up, but
thing.
Thought it was very clever and amusing because you remember
very clever.
Brett Kavanaugh talking
sure,
about
he
beer.
got lots of shares on Twitter. But anyway, so a constitution does prohibit religious tests for office. That doesn't just mean that you aren't going to get a bunch of people of one religion in office. In fact, if you had a way of preventing the accumulation of people of particular religion in office, that would be, I hate to break this to you, that would be a religious test.
Yeah, exactly. You would need a religious test to prevent, at least, to absolutely prevent a random agglomeration of people of a particular religion.
Yeah. And in fact, the religious test clause, what that means is you can't have prescribed by law. So this is a separate point, but people make mistakes about it all the time. What it means is you can't have prescribed by law a requirement that somebody, sign some kind of oath saying, I'm a Protestant, because they did have that in the United Kingdom.
It's called the Test Act.
The president could say, I'm only going to appoint Branch Dravidians to the Supreme Court. He could say that out loud, and he could appoint only Branch Dravidians to the Supreme Court. That would in no way violate the Constitution. He's allowed to do that. He's allowed to have his own criteria for appointing people.
As not about religion, but you will remember President Biden said that he was specifically going to nominate a black woman to the court. And that wasn't unconstitutional for him to do that. Yeah.
And that's, again, I think that the Senate would probably not give their consent to a bunch of Branch Dravidian nominees. And I think if the president openly voiced, I'm appointing people of a particular religion, I think the Senate should view that with a great deal of suspicion, and they should probably not confirm those appointees because that's a bad reason to appoint someone to the court. I think that really kind of filling a box for any kind of demographic category, I think is a pretty bad reason to appoint someone to the Supreme Court. It could be a consideration, sure, but it shouldn't be your sole reason.
Yeah.
And I think Biden was foolish to say that. That's sort of my political opinion on that, I guess. But that says nothing of my opinion of Justice Jackson, by the way. I think that she actually is qualified in terms of her past experience. It's actually very similar to other people on the Supreme Court, which is kind of funny because he was trying to get some diversity on the court, and I think he kind of really utterly failed there. But anyway, I think that just talking about saying the reason that I'm picking somebody is because she's a black woman, I think that's not great.
Yeah. Anyway, okay. So this next one, and at your request, I went and I looked for a suitable part of a Hollywood production. So I was doing some searching on the internet and I came across a description of something that sounded so absurd that I had to go and verify it for myself. I don't watch this show, but this is apparently some kind of HBO drama called Big Little Lies.
I think I've heard of that.
As far as I've been able to determine, because like I said, I don't watch the show, this is a clip from a custody trial that involves a grandmother trying to get custody of her grandchildren. Her son, their father, is dead, and she's accusing the mother of being an unfit parent. So I believe that's the context here.
Do her children become the property of Carl's Jr.?
Is that from Idiocracy? I don't remember that.
That is from Idiocracy.
Okay, well, cool.
Yes, you are an unfit mother. Your children are now the property of Carl's Jr.
Okay.
That would not be legal, by the way.
I'm glad.
Children are not property.
I'm glad.
Yeah.
All right.
And they generally won't give corporations custody either.
Did you ever strike your mother-in-law?
I slapped her in the face.
Ever push your husband down a flight of stairs?
No. And how dare you? How dare you?
I mean, it's sort of his job, but...
This is a computer simulation of your husband's fatal fall.
Objection. Relevance. Not to mention...
Relevance?
Your Honor,
Really?
take it
We're not going to say that it's speculative or...
Yeah, but hold on.
Okay, this is off the chart. Prejudicial.
This
How
isn't a jury trial, counsel. I'll give you time to impeach if you want.
This is where your husband would have landed from a natural fall. Now, this is where he did land.
It's not even an expert witness to testify about this. It's just play. So you guys can't see it. They're playing a computer animation of a guy kind of tumbling down the stairs and saying that if he'd fallen naturally, he would have fallen differently than the way that he fell here.
Yeah.
Because the simulation says so. The lawyer just shows this. No one's testifying about it. And he's like, witness.
Yeah, no, look,
what of this?
It is not a very impressive looking, because I think this show came out like a few years ago. It's very recent. This is not a particularly impressive looking computer model even. It looks like
and if you've ever been in trial, you know that any graphic that a lawyer presents is never going to be impressive looking. So that's typical.
It has the appearance of something where it's like, you were, a high school student screwing around in a computer science class might have produced this animation. Like, we have no evidence that it's reflective of any actual, physics model that might go into, it's just an animation of a guy falling, basically.
And then, but her lawyer, he's on the ball. He objects and says that it is irrelevant?
Yeah. Hold on. I forget if there's more to this. Let's let it play for another few seconds and I'll cut it if it's not.
Play us out.
The physics say that for him to have landed there,
the physics say
he must have been pushed.
Yeah, the physics say that.
So
that's just, he doesn't say, like, you heard the expert witness testify earlier that the physics say so on and so forth. The lawyer is just introducing this on his own.
Yeah.
And opposing counsel just sits there twiddling his thumbs being like, I guess this is fine because the physics say so.
I showed you an animation. Clearly, the physics are on my side.
Yeah, Your Honor, request for judicial notice that this animation perfectly reflects physical reality.
Yeah. All right, I think
it's probably not funny to anybody, but it's funny to me. So
No, I did not.
How did he fall?
He lost his balance and he slipped.
He lost his balance immediately after you found out he'd been unfaithful with another woman who bore his child.
Assumes facts not in evidence.
Yeah.
You can't just say that. Lawyer can't just...
Yeah.
Assumes facts not in evidence.
Yeah.
Your Honor, this is not relevant.
Not relevant. She might commit a homicide, but hey.
What?
Objection.
All right, the objection on
to do with
relevance
relevance.
is sustained.
She objected on...
It's very relevant. That's true. That's very relevant to whether or not she pushed her husband down the stairs.
Yeah, and you'd think they objected to relevance on this whole situation too. You'd think, if you could actually prove it under legal standards that she had
very relevant.
Murdered her husband, I feel like it probably makes sense for her to not have custody of her kids.
Yeah, that's extremely relevant to the custody question. Relevance is not the issue. You could say maybe it's unduly prejudicial, or that it assumes facts not in evidence, or that it lacks foundation. Lots of this diagram, not diagram, but this simulation is not authenticated.
Yeah.
Lots of other problems.
Yeah.
If I were the judge on that, I'd look at the lawyer and be like, really? That's what you want to object to? You want to try again?
Yeah.
I'll give you another try.
Yeah. Keep going. You get 3 strikes.
Yeah. You're on the right track. I mean, objection was right.
Yeah. If someone used this as like a teaching tool in a law school class, not that I think they should, that seems like a weird way to teach a class, but I feel like that's, someone trying to coach you through, no, you're right to object here. But, what are you?
I only had one time in my law school experience where I was taught using a video clip.
Uh-huh.
And you know what it was?
You may have told me at some point, but I don't remember if so.
It was John Eastman in my property law class, second semester of my 1L year, my first year. And we were learning about rights of succession. Mm-hmm. So he played a clip from the beginning of Henry V.
Yeah, which we talked about. We talked about Henry V last week, right?
It's the famous one where they're making the case for why Henry V has a valid claim to the French throne.
Yeah,
and it goes on and on and on about the Salic law, and then he concludes. And I think it's supposed to be kind of, we talked about this last week, didn't we?
Yeah.
But anyway, it concludes, "'Tis clear as is the summer sun that you have a claim to the throne here," and Eastman pointed out to us, actually is clear as is the summer sun. But anyway, one more.
Yeah.
Hot take.
Yep. Last one for this time. And again, it is Twitter. So before you complain about it, acknowledging it's Twitter, just get past it. All right.
I won't even comment on it. Okay. So Robbie says, the Constitution that over 2+ million service members took an oath to support and defend protected the right to abortion. Now it doesn't. So now all current military contracts are null and void, and all troops can leave their posts immediately with honorable discharges. Yeah, try that. See how that goes.
And I think even setting aside that, yeah, I don't think the military is gonna award you that honorable discharge you're looking for if you cite this as the reason. Turns out the court found that the Constitution doesn't actually protect that.
That's actually, for our teaching purposes, that's the important point to make here, is that when the Supreme Court overrules precedent, they are not changing what the Constitution says.
Yeah.
They are saying they got it wrong the previous time.
Yeah.
Because remember, judicial opinions are evidence of law. They're very good evidence of law.
Right.
The higher the court, the better the evidence of law they are. They are not law itself.
Yep.
Law itself is the Constitution. So they can get it wrong, which is what happened.
Yep. All right. Anyway, pretty neat and simple one, but yeah, I would.
That's it. That reminds me of those, like, oh, if you do this one neat trick, they can't get you. Like,
yeah. I almost
very silly.
I almost had a different one of those for this time. Maybe we'll get to that one next week in hot takes, but
those almost never work.
No,
that's not good.
Yeah.
Don't.
I think I mentioned this at one time before, but common law, Anglo-American common law, is pretty old at this point. There were
about 2,000 years.
Yeah.
Well, I guess technically common law dates back to Edward I, right?
Yeah, I believe time immemorial is defined in Britain legally as dating from the end of the reign of, I want to say, Henry II, something like that. But there is a specific time.
So a little bit after the common law.
For time immemorial. But yeah, it's basically, it basically overlaps there. But anyway, my point is that just that if you think you've found like this sort of silver bullet to just like evade consequences for doing something that should clearly be illegal, you probably haven't. Can't guarantee that. You should always consult
you may
with an attorney.
have. And if you really think it's a good one, give us a call. We'll give you a free consultation. You can talk to me for 30 minutes with your theory, and maybe it's a good one. And if it's a good one, we'll probably take your case.
Yeah.
So, but in all likelihood, it's probably not.
Yeah. Before you stake your freedom or other important things on having this magic silver bullet legal trick, you should probably talk to an attorney. Could be us, but it doesn't need to be. And by us, I mean the Institute, not me personally, since I'm not an attorney. But anyway, I think that will probably do it for us, though. Thank you for listening, and we hope that you'll listen again.
Yeah, and remember, liberty, equality, fraternity, or death. Is that our sign off today?
Sure. On that note, I think it was actually one of the king's cousins or brothers was the Duke of Orleans at the time of the Revolution. And he was addressed as Philip Orleans. He joined in with the revolutionaries, became a very enthusiastic member of the National Assembly, and he changed his name to Philippe Égalité. So basically,
Philippe Equality. Very good.
Phil Equality, as we might say in English.
Phil Equality. Yeah, I'm not a big fan of that. That's like there's this guy in California that always runs for various, like, whether it's county commissioner or various offices like that, and his name is, on the ballot, it says John Lower Taxes Low.
I remember you telling me about that guy. Yeah.
And it always runs for those offices where you never know any of the people running.
Right.
So, I assume he thinks that he can win through people liking the name.
Yeah.
I don't know if he's ever won anything before.
Probably not.
I won't say whether or not I vote for him since it's a secret ballot and I don't have to. But that was, I thought, an interesting strategy.
Yeah. Anyway, I think that's going to do it for us. So thanks for listening. Goodbye, everybody.
All right. Good night, folks. And if you can't get enough of the Lex Rex Institute podcast, well, listen to the old episodes. We've already done that. We've got plenty of videos on YouTube for you to peruse. Some of them are boring. We're going to improve them. They'll be less boring in the future. But if you can't get enough, listen to them anyway. Or you can listen to me appearing on the Kira Davis podcast from a couple of weeks ago, or this new one that I was just on today with Steve Hilton. Those should both be up. So yeah, you can get plenty of Lex Rex Institute content out there. Anyway, thank you guys for listening. Have a great evening, and we will see you folks again next week.
All right. Bye.